My Lords, I'm about to turn to the electronic bill, but before I do that, I want to start with just one broader point that is relevant to what I've said on the paper bill, but I will come back to it when I deal with the electronic bill as well, which is the issue of, as I put it, initial stroke canonization. And my submission is, and I will come on to seek to deal with this point, but just so I put a marker down, on the electronic bill, I will seek to submit that the judge, looking at the judgment as a whole, found that you need the name, not just the initials, but I'll come back to that. But in broad terms, obviously one can have initials in two ways. One can have initials that are the actual initials of the person, or one can have anonymized initials, and that's an important distinction to make. And insofar as it is said that anonymized initials might suffice, that brings me back to all my points about why anonymity is unhelpful. You can, and in fact, for what it is worth, in our new points of dispute to the new bill, with one fee earner, him having been identified, we do take the point that actually he's not a grade B as he's claimed, because the qualification isn't a relevant qualification, etc. But the point is a general one. If you know the name of the person, and they're a solicitor, you can check on the Law Society website. If someone's called a legal executive, you can check whether that is just a term, as it frankly often happens, that a solicitor has chosen to use, or whether it means fellow of the Institute of Legal Executives. And when you have the name, you can check that kind of thing. When you don't have the name, you can't. And whereas it may often be the case that a cost judge will look at the relevant grade, it is by no means, it is certainly not permissible and not unknown in practice that the cost judge will look at the characteristics of the individual fee earner and may say, well, I'll allow a bit more for this person because they have increased experience beyond what I'm allowing for others of an equivalent SCCO grade. And as I say, it does allow challenges to the categorization. So that's why, in my submission, in general policy terms, anonymization is wrong. As to whether actual initials are right or wrong, that would leave us in a haphazard position where it may be that from the initials, the receiving party can work the name out because they've had correspondence with the reference on, or they've done another case against the same solicitors and they've worked it out from a previous assessment that, I don't know, AKC is so-and-so because that's what they've been told in a previous assessment. Or it may be that they can't work it out. And that I say, is an incoherent position. So I do say that the right answer is that the name is required. And I've made my submission as to why, on a proper construction of the old rules, 511, that is appropriate. I will come back in a few minutes as to why I say that's the right approach under the electronic bill as well. But just before I do that, so related to the point I've just made, your Lordships were pressing me on is it okay to have more junior fee earners simply as others? And my submission in sum was, that's not what the rules require, though it may be a less significant breach and therefore not require wholesale remedial work in practice that a more significant breach was. And I just wanted to make the point that when one says, well, it can be assumed they're all grade D, I've already made the point that in reality, a receiving party may try and up the grade on instructions at the hearing, and that's not satisfactory. But there's also the point that although, of course, I appreciate one isn't held to guideline rates, whereas, for example, one might say, as the case here, that the grade D fee earners are claimed above what one might regard as the norm for grade D fee earners. It may be that for some of those grade D fee earners, they will have a bit more experience and the judge will allow a bit more, but for other fee earners categorised as grade D, the judge will allow a bit less. So it really comes back to saying, even then, it is at least desirable to know the name, because the answer as to the recoverable rate might not be the same for each person. And that's particularly the case where it's not what you might call the common or garden grade D rate that's being claimed, but as often happens, even for grade D fee earners, what might be described as an enhanced rate is being claimed. So that's all I have to say by way of revisiting those points. And I'm going to turn straight away to the electronic bill. Your Lordships, of course, have had the opportunity to study closely the relevant provisions of the practice direction. But I just want to draw attention to one other one, which your Lordships may well have seen, but I've not really been focused on in oral argument today, which is in the authorities by the bottom of page 8 and top of page 9, paragraph 5.A3. So the way this new practice direction is slightly back to front, it deals with the electronic bill first and then goes on to the old paper bill. But 5A3 is, if not a transferring, I suppose, rather than transitional provision, says that the provisions of paragraph 5.7 to 5.21, and that, of course, includes 5.11 that we've been looking at for much of this morning, of this practice direction shall apply to electronic bills insofar as they're not inconsistent with the form and content of precedent S. Now, I don't need to read the rest of that rule, but I do, just before I come to the precedent S rules themselves, sorry, the new bill rules themselves, the electronic bill rules themselves, make the point that if and insofar as I'm right, particularly on the name point under the old bill, then this provision means I get home without more under the paper bill. If I'm right under the paper bill, this provision means I get home without more under the new bill, the electronic bill. And I just want to draw a couple of other points from this. The first is that although this isn't directly on point as to whether you're required to put in your bill, your electronic bill, everything that's in precedent S, it is quite a strong indication, I would submit, that precedent S isn't simply something you can take or leave, because this transferring provision is conditional on certain rules not being inconsistent with precedent S. And I say that's a strong indication that precedent S is, at least in some form, something that you are required to respect. It's not, as I will seek to characterise the appellant's submissions, essentially that you can take it or leave it as a receiving party as you please.
Well, it provides the minimum level, you say.
Yes.
It's the floor against which everything else has to be measured.
And the other thing you get from here, and it is the distinction or the passing of the form and content of precedent S. And I say that a lot of the flaw that underlies the appellant's argument is the failure to distinguish, and this essential argument, we don't have to use precedent S. Therefore, and this is my characterization of what they're saying, therefore we can basically do what we want, fails to distinguish between form and content. And I'll come back to that. So that's my not terribly elegant segue into the electronic bill, to which I will now turn directly. And because it's a point that the courts raise, let me deal straight away with whether on the judge's determination, initials rather than the name were sufficient. And I put it this way, not least because I haven't put in a respondent's notice, that on a proper understanding of the judge's judgment, she required, her holding was that the name was required. And just as a preliminary to this, I mean, I hope I can say without controversy, that the argument below was between me saying, you've got to have the name of each fee earner, and my learner friend saying, as the court has heard him say this morning, the bill as presented is perfectly adequate. There wasn't a specific submission made to the judge below on, well, okay, even if I need to do more than is in my bill, I'm allowed to give initials, but I don't have to give the name. And your lordships will see that forms no part of her judgment. Nonetheless, it's a point that the court has raised. I recognise the court's here to deal with a point of general importance, and I can deal with the point, so I will. But it's just as a preface to what I have to say, that is why there's, in my submission, no real focus on this point in the judge's judgment, because it wasn't raised before her. But I do say that the judge took the view, if one looks at her judgment as a whole, that the name was required. And can I then go to the learned judge's judgment, please? Your lordships, of course, have that at tab 9, page 65 of the core bundle. And I just want, firstly, just to go to paragraph 2. And it's the second half of that paragraph that begins about six lines down, summarising, I was the appellant there, my submission on the electronic bill. The appellant contends the electronic bill failed properly to give the name, the grade, the date, etc. So the judge recorded the submission, quite rightly, that I was making, that the name was what I was saying was required. I will then jump straight away to paragraph 109. And her ladyship did say, as my Lord Justice Newey pointed out, that at the beginning of paragraph 109, at page 92, the judge replies, the respondent's electronic bill, this is now the judge giving her own commentary, not recording a submission. The respondent's electronic bill does not include the name or initials of the fee earners. I mean, I say that she just really added in parenthetically that it didn't even record the initials. My submission would be that the judge was not there indicating that the initials would be enough. And I say that really for the broad reason that in some, that the judge, it's clear reading the judgment as a whole that on this point the judge accepted the appellant's submissions, and she was clear that that submission was, that a name was required. But there are further indications that that is what the judge meant, that a name was required. And I get that from, firstly from paragraph 110, where the judge criticises the bill and says in effect, because where they should have put LTM name, they simply repeated the code that was under LTM. She says that the effect of that is as if the respondent had left the column blank. And it's clear in context that the judge is saying that she's finding that that was not acceptable. So the first indication that the judge, apart from the overall point that she was accepting the appellant's submissions, that the judge considered the name to be required, is that she clearly found it unacceptable that a column effectively be left blank. And so my submission would be that one can draw directly from that that the judge would find it unacceptable if the name was left blank. The other indicator I get to that effect is just over the page of paragraph 114, where the judge puts the cost judge's contrary conclusion that she rejected. So she says the cost judge was wrong to conclude that because the bill of costs does not have to be in precedent S format, there is no requirement of the practice direction that the electronic bills must disclose the status and SCCO grade in respect of each individual named fee earner. So she is saying, the learned judge is saying that the cost judge below was wrong to conclude that there was not a requirement for the grade of each, I underlined, named fee earner. So, but nonetheless, that doesn't necessarily mean the judge was right, but I do submit that that was her conclusion. So dealing with whether that was the correct conclusion, I said I would come back to this. I've made my overarching point about why anonymised initials would be undesirable and why initials that were actual initials that would leave it down to happenstance whether the paying party could or couldn't work out the name of the fee earner would be incoherent and also undesirable. But I recognise that I need to deal with the example in precedent S, the populated example spreadsheet. Do your lordships have this conveniently to hand?
The Excel spreadsheet.
The spreadsheet, not the cost bill in this case, but the precedent S populated spreadsheet.
Well, is it paragraph 47 of the judgment?
Yes, we can get it.
I'm afraid we didn't.
No, I'm sorry, well, let me deal with it. Well, let me deal with it then.
Paragraph 47 gives you a bit that's relevant, doesn't it?
Yes, that shows exactly what it shows. I'm very grateful. I mean, the first point to make is that although we've referred to initials, I mean, it doesn't actually say, I mean, not that I'm encouraging anything more opaque, but it doesn't actually say initials. And what you've got here is a requirement for the name, leaving to one side, and I know I'm going to have to come and deal with it, NLB. But what you've got is the name, and then a code, which is the initials, and I'm certainly not encouraging anything more opaque than that, that directly correlates to the name. And the reason for that is actually very straightforward. When one goes, and I appreciate your lordships can't do this, but when one goes to worksheet 14, which is a worksheet which, if you printed it out, has so many columns, it'd have to be a very wide piece of paper, which is no doubt why your lordships don't have it in paper format. You have each entry, you have an entry and you recognise the fee earners, but for what it's worth, the way the fee earner is identified is not by LTM name, it's by LTM. And my submission is the reason for that is simply that it's a narrower column. Instead of having to write out the person's name every time, you just put WT, or maybe WT1 or 2 to differentiate between different rates for dates. So the reason for the LTM in worksheet 5 is simply that when you get to the detail of the bill in tab 14, instead of having to have a wide column that has the name, or you narrow the column and then you can't see, you can indicate each fee earner just by 2 or 3 characters.
Well, it says WT1 or NLB.
Yes.
Or, yeah.
So if you go to worksheet 14, every entry will be attributable to an individual person because it will say WT1 or FD. And that's simply when you're dealing with a very wide spreadsheet, a lot easier, and a lot easier to filter than having to put the name in, because then it's an even wider spreadsheet, or you compress the width of the spreadsheet and then you can't see what that column, you compress the width of the column and then you can't see what the column says.
And this is the bill detail one on the...
That's the bill detail on tab 14. And I mean, your lordships can see that in the precedent. I mean, I think your lordships can actually see that in the claimant's bill. And your lordships can see it in the claimant's bill that it has LTM, and then they've used the code. But the problem with their codes is that when you go back to worksheet 4, you can't actually tell who it is.
You can't tell which fee earner it is.
You can't tell who it is. So that's the answer, and I appreciate. And again, in the end, if I fell on every other point, I would just say it's not a point on which such significance can be taken. That in one of the examples, but only one, the name isn't given, and that's the point that my Lord Justice Newey made. That one sees that for NLB, the name isn't given. I don't know why that is the case. And my real submission is that's too slender a basis for interpreting LTM name in the second column as meaning anything other, and not a basis for saying it's optional. But it may be, if one goes in the sample spreadsheet if one goes in the populator spreadsheet, that this NLB only has 2 entries. Medico-legal assistant is something that's often outsourced. It can be charged as an outsourced profit cost rather than disbursement, but it's certainly not unheard of for solicitors to outsource the reviewing of medical records, which is essentially the 2 entries. If one looks at this precedent at worksheet 14, the 2 entries for this person are to do with outsourcing medical records reviews and collating and paginating medical reviews and collating and paginating records. That's the kind of thing that can be outsourced, and it may be that the simple answer is that that code is a reference to the outsourced agency.
So would they be a legal team member, in fact? Or
Well,
is it contracted at the point? Or?
There is authority that says, well, it may not be, I don't know, it may be an individual it's been outsourced to, hypothetically, it may be an organisation. There is authority that says that if it's a case called Crane and Cannon's Leisure, which I remember from my younger days, where the Court of Appeal held that if it was work that the solicitor was under the retainer personally responsible for, they could outsource it, and this was to a cost draftsman in detailed assessment, and they could make their own charge as a profit cost for that work. So that's why it wouldn't be a disbursement as opposed to a profit cost. Yeah. But it may just be that this is, in the mind of the person populating the spreadsheet, an example of a small piece of outsourced profit cost work. But my overall point is, curious though it is, there isn't a name there. It's not a basis, and I'll come back to this when I deal more holistically with what's required under the electronic bill. It's not of itself a basis for holding that in general terms the name isn't required, because there's clearly a box for it on the spreadsheet.
I mean, the argument for saying that a name is required is most obviously that you have to use precedent S or something like precedent S, and precedent S includes a column saying LTM name. But then it is a bit of a worry that when you actually have a populated version, which you're taken to by the rules, or by this direction, you find in one instance no name is given.
Yeah, well, my lord, yes, but it is only one instance for someone who has 2 items on the bill. And it may be that the person preparing this example had in mind that that is the kind of work that's often outsourced, and maybe not an internal fee earner whose name was known.
In terms of the first point, only 2 items. Well, supposing that Fiona Duggan had only 2 items, you wouldn't say it was all right to leave her name.
No, I mean, it's more the nature of the work. I mean, I don't assert that that's what was in the draftsman's mind, but it's an explanation. But my real point is the overwhelming weight of the argument the other way. And your lordship is right, it's not a complicated point I'm making. That there's a column there that requires the name. And it's pretty obvious, in my respectful submission, that you're expected to complete it.
And they must have known the name, because they've got NLB. They haven't got MLA, Medical Legal Assistant.
No.
NLB must be...
Unless it's an organisation. But no, I take that point. I do.
While we're just on the bill detail, they do give the name for counsel, but if you look at items 84 to 87, it says paid fee to counsel Oliver Williamson for advice, which on the face of it doesn't make sense when you look at the details of the legal team that is given.
I'm sorry, my lord,
Well, if you're on bill detail 14,
yes,
and 84, for example, it says paid fee to counsel, who we knew was Nicholas Steyn, I think it said, and then it had Oliver Williamson for advice.
Yes, I mean that. So I'm struggling. Is your which bill is your lordship on? I'm sorry.
On the bill on the copy of precedent S example that we were sent, on bill detail 14 and line 84.
84. I'm sorry, I'm looking at something quite different. You're on tab 4. Your lordship's on tab 14.
Yeah.
Is your lordship looking at the Owen Mitchell bill or the precedent?
No, I think this is the precedent one because you've got the legal teams that it ties up with Nicholas Steyn, junior counsel.
Sorry, I'm being helped. I'm grateful. Sorry, I'm looking at the wrong.
I don't think anything very much turns on it, but it just might be a point either relevant to issue of name. Because we've got Nicholas Steyn, junior counsel, and then it says paid to Oliver Williamson, but who Oliver Williamson is, it's not explained.
No, it may just be that, yes, I mean, the answer may just be that the examples haven't been completed with with absolute care.
Well, yeah, well, I suppose that may then be a relevant point to note. Yeah.
I mean, yes. I mean...
Sorry, it was only a point of detail, but as we were trying to chase down names in the bill detail, I couldn't follow that particular one.
No, I can't, other than suggesting that perhaps it hasn't been done with perfect care, I can't provide an explanation for that. Of course, what I can, I mean, there are two precedent S's. I mean, I can't completely dismiss this one. There is a precedent that has no detail on it at all.
Yeah.
And if one looked at that, I would say it would be complete. Your lordships will have my point that there's a column and therefore it's completely obvious. It's only, no doubt, an attempt to assist people where they have provided a second precedent that has example data that the problem arises, but it is only example data.
Yeah.
It's not strictly an assertion that this is an example of what a solicitor might do, I could say, not an example of it being done super perfectly.
But what it may indicate is that the draftsman of CPR 47, when they said maybe in either precedent S spreadsheet format or any other spreadsheet which does the following, didn't actually intend or expect everything to be put in, unless it was actually required under A, B, C, D or E.
Well, but that begs the question, my lord, what is meant when it refers to full functionality and detail and also transparency?
Yes, that's it. That's why the fact that there's a gap there is interesting, but you say if it doesn't prevent full functionality, because you've got enough here with the initials, so it may be name or initials if the initials will enable you.
I mean, if the initials are someone you know, I mean, it may be that that's being, if you can work it out from the initials, that would be enough. But in terms of what ought to be done, my submission is that the name ought to be included. Otherwise, I mean, if one takes the appellant's argument to its logical extreme, they say, well, we essentially comes down, and instantly, my Lord Justin, he was right, they did call this precedent S when they served it as well as when they filed it. But leaving that aside, the argument in a nutshell, as I understand it, is because we don't have to use precedent S, we therefore are not in breach of the rules if we leave out some of what precedent S requires. But you do end up going either one of two ways. Either you end up saying that on a proper construction of the rule, which includes an explicit reference to precedent S and refers to terms like functionality and detail, which are not otherwise defined, and therefore are only given any certain information by looking at the referred to precedent. You either say that they have to essentially have the substance of what precedent S requires, although they can use a different format. That's the way I go. But if you go the other way, then the logic of the argument isn't just that what the solicitors did in this case was permissible. It's essentially that any solicitor can really take it or leave it. They can take this column out, maybe they can take the grade column out, the status column out. Why shouldn't they be able to take, I mean, or to take a slightly facetious example, the detail of work done column out? I mean, it really, one either
because
goes...
he says the detail of all the work done.
No, that's a fair point. I'm not going too far
You've
there.
got to comply with.
But you could take out a number of the other columns that are not specifically referenced. Your Lordship makes a very fair point there that would actually fight against the wording of the rule.
I mean, I do wonder whether really here it is C, detail of all work undertaken that we're concerned with. Just going to E, contains all calculations and reference formulae in a transparent manner. Well, presumably that means if you've got a spreadsheet, everybody's got to know what formulae it's using.
Yes.
And that's not a complaint about this bill. So as to make its full functionality available to the court. Well, provided you know what it's doing, its full functionality is available to the court. It may be deficient in providing the detail, but you can still have its full functionality. So at the moment I rather feel we are back to C, detail of all the work, and there I follow your argument that the only guidance we get as to what detail is required is from the precedent S.
And I would, yes, well, I mean, I have relied on full functionality, but I'm quite prepared to accept that the focus is on detail. And then what does detail mean? I mean, obviously, without further definition, it's open to an enormous range of permissible meanings. As I say, you do, in my submission, it's essentially a stark choice by either I'm right to say you either need to have precedent S or something which my word is equivalent and therefore includes all the information that precedent S requires, or if it doesn't mean that, then we're in what I would submit as the remarkable position, and your Lordships don't need to go into the detail of the reforms to see this, that we've had these, a lengthy report, great deliberation. I think one thing my learned friend didn't mention in his brief history was there was a pilot scheme of electronic bills, and all that is done for the stated purpose of improving functionality and transparency and better levels of information. All that has been done, but in the end, a receiving party solicitor can just take it or leave it as they please.
So really, it's a free-for-all.
Yes, yes. I would, if I didn't use that phrase before, I certainly would use that phrase. That a receiving party solicitor, after all that work in working out how to have an improved detailed assessment process and improved information, they can just ignore that, and that would be extraordinary, in my submission.
Just while we're on this, though this is really a point to mention to Mr. Brown. Over the short adjournment, Judge Rowley drew our attention to the Hutton report, which obviously predates the pilots that you referred to. And so what you get from it may be limited, but the Hutton report, I see, does include a reference to identity of fee earners. Well,
I'm grateful to have that pointed out. I'm very grateful to the court's assessor for pointing that out. I mean, that may be a point that helps. It sounds like it might be a point that helps me. But the broader point, the way I put it in my skeletons, your Lordships don't need to look at the background material because it's apparent from the rule. And if one looks at 5A1 and 5A2, there's a specific reference to the precedent S. The qualification on which the appellant hangs its hat is saying that the electronic bill may be in its precedent S spreadsheet format or other spreadsheet format. That's not set, so that, if anything, is equating to what in the slightly later rule is form, but it's not in my submission equating to content or detail. And the content of the detail have to be what precedent S mandates. Otherwise, I mean, as I said, your Lordship has my point, I think. Either that's right or it's a total free-for-all.
Going back to the rule, sorry to be obsessive about the words of the rule, allows the user to identify the detail of all the work undertaken in each phase of chronological order. that's telling you what work has been done. 2 letters sent out, instructions drafted. So that's nothing about who did the work. And then E says contains all calculations and reference formula. I'm not sure what that means unless it's multiplying the work by the hourly rate for the person who's done it, so as to make its full functionality. And it's a lovely word, but what does it actually mean in English, functionality? Does it mean you can check from each part of the bill? I can type in Marvin and I know exactly what he's done?
Yes.
What is it actually meant to mean?
I submit it does mean very much that. And what you can do, if you're given the name, is you go to precedent 14, and indeed the court's assessor may confirm this is an exercise that's often undertaken when one gets to the detail. You go to worksheet 14, and you can set various filters, and therefore you can see exactly what, you can filter by all kinds of things, phase of work, category of work, but you can, for example, identify and see immediately, one after the other, all the work done by a particular fee earner.
And that's... Oh, sorry, I thought you finished.
Yes, I had.
The functionality goes beyond that because, for example, you've got on line 9, point 2 recorded. If you put in point 1, then you automatically get a reduced figure across on the Excel spreadsheet.
Yes,
and that's what I'd understood the functionality to mean.
Well, yes, I mean, it's both being able to alter the data so that when the bill's being assessed, and that's what the cost judge or one of the parties will do, they will change the figures on tab 14 so you get to an assessed bill. But it also, before that, I would submit, means seeing the detail. So, for example, if one fee earner has claimed an implausibly large amount of time, which I think is one of the examples Mrs. Justice Steyn referred to as a possible mischief of not having the name, if you can filter by name, if one fee earner has claimed 16 hours in a day, that might be a flag. But of course, if you don't have the name, and I appreciate this doesn't answer the anonymisation point, but if you don't have separated fee earners, then you can't do that because you don't know if it's one fee earner or 2.
Because it's full functionality was the first thing, and then I read the next bit, because I'm very slow, and it says available to the court and all other parties. So it's looking at what use the court is going to make of it and what use the other parties are going to make to it. And it must enable them to function.
It enables us to interrogate the bills.
Or interrogate, yes.
Yes.
And different people will be doing it for different ways. So it may be you want to check whether or not it's the same person who's done, 2 people done the same work. The court may want to recalculate if they're going to reduce it from £400 an hour down to £200 an hour. But the point is that it's all to do with everyone being able to see, interrogate and use that information to work out what cost level is reasonable for what's being charged for, is it?
Yes.
Just before you, I know, I suppose possibly disagreeing with Lord Justice Lewis, I wonder whether it does mean that. It says so as to make its full functionality available. So it sounds as though you've got to make whatever it can do available, rather than saying what it must be able to do.
Yes, that would become circular, I suppose. If it can't do it, then it isn't made available.
I mean, if it's a pure paper bill and it can't do anything, well, its full functionality is still made available.
And what it's got to contain is all calculations and reference formulae in a transparent manner. And it's because you've done that, or the way in which you test whether it's a transparent manner, is this reference to whatever functionality means the court or all the parties. We haven't actually looked at the word of the rule to find out what it is that requires the name to be provided.
When it refers to its functionality, and it's perhaps, I was about to make the slightly opposite point, that actually, apart from the transitional provision to which I have referred, but one, obviously, the transferring provision at 5A3, one of the things that actually struck about 5A2 is what it doesn't say, and that's one of the reasons you have to construe it as meaning, I mean, it doesn't actually say anything about grade. It doesn't say anything about status. Those are both columns in the precedent S. Insofar, can I just make that point, because I know my learned friend was pressed on this by the court as to what grade and status meant. Just to be clear, in the electronic bill, there are 2 different columns, one for status and one for grade. It's not, so clearly, I mean, I don't know if this point's to, but clearly grade means SCCO grade, because that's what everyone knows it means. But also,
and that may give the information for status, but status is, you say, the combination of everything.
But it doesn't. But it must mean that. Otherwise, if it's just a more general term, it doesn't add anything status. So I just make that.
But it could be, it could be that if you fill in the grade column, that's good enough for status.
Well, it may be. I mean, it may be that if you fill in the grade column, that's good enough for status, and it's really only if the receiving party wants to say, this is a super added grade A, he's a very senior partner with 20 years experience, they'd want to put that in. But yes, I accept if you have the grade, then status becomes less important.
So just playing devil's advocate, which bit of the rule do you say requires the name and why?
I say it's the rule that says that refers. It's taking the rule together and saying you can use precedent S or another format, which does the following, and then allows the user to identify the detail of all the work undertaken in each phase. And really, I mean, apart from a purposes construction of saying, and I appreciate this is a slightly sort of blunt instrument of saying, all these people didn't go through all this trouble simply so that a paying party could take it or leave it, and it was a free-for-all. And what I say is looked at sensibly. You have to construe detail to mean the detail in precedent S, and that includes the detail of the work done isn't just what was done, but who did it.
Right.
But my Lord Justice Newey is right. There are really three hooks on which it's hung in the judgment: detail, transparent manner, and full functionality. And I entirely accept that the most directly relevant one of those is detail. And if detail doesn't have a specific meaning informed by precedent S, then it isn't further defined, and it is a free-for-all.
That may be the way to put it, is that precedent S informs the meaning of detail.
And it's only the format that you can depart from. It doesn't say, it says they can be in precedent S format or any other spreadsheet format which does the following. And I say on a construction that means where the terms are not self-evidently precise or which are not further defined. It means which does the following in accordance with precedent S.
Well, if S treated detail of the work as including who did it, any other format would also have to include the same detail.
Just so.
In however way they presented it.
But as I say, and I appreciate this is an unsophisticated submission, but really, if it doesn't mean that, then it is a free-for-all, and all this work of providing a new electronic bill that's supposed to be an improvement for everyone on the old bill has been at naught because the paying party can take it or leave it. So forgive me, the receiving party can take it or leave it. Can I just add two other things on that by way of context? Again, without delving into the detail of, and it's all set out with painstaking thoroughness in her ladyship's judgment, of the background material. One point that is apparent that I would just draw attention to is that one of the purposes behind this new electronic bill is, I have to say, looking at the time on this bill for preparation, the reformers might be somewhat disappointed, the enormous time spent on this bill. But the idea is, instead of having hours or days or weeks of a cost draftsman's time drawing up a paper bill, it can simply be electronically transposed from the fee recording software to the bill. And that's another powerful indication that it's done by name, because of course, the fee, or certainly that it's separated out, because each individual fee owner will of course be recording their time individually. No solicitor, no business would have it any other way for all kinds of reasons, internal as well as external. So I just wanted to draw that point out. And the only other thing I would just go to in terms of background and contextual material is, and your lordships have it all, the lectures, the report, is the SCCO guide, which your lordships have at tab 9 of the authorities bundle. In particular, is discussion of worksheet 14 at page 249. In fact, it's 250 that I just want to show your lordships. And I mean, what your lordships, of course, it's a matter ultimately for your lordships, not for the SCCO guide, but the example at page 250, it sets out as one of the key advantages of being able to manipulate this bill, that you can go through this and you can go through that and you can see exactly what Mr. Taylor, the theoretical Fiona, has done on a particular day or on a particular task. So the sort of commentary on the precedent S, is an important part of it, that you can look at it, and the way it puts it, as an individual named Fiona, you can see what he's done on this task or what he's done on that day. And of course, as your lordships put to my learned friend, and I say this with respect, if my submission didn't receive a very good answer, is why not? What is, why not just give this information? There really is no good argument against it. And that's not just relevant to a broad merits point. It's relevant to the approach to the construction of the rule. If something is obviously helpful and there's no good reason for not doing it, then looked at objectively, that is a strong argument that that is what the person preparing the rule intended. And I do stress that although, given that your lordships are construing the rule, neither of us has really gone to the new bill or the new points of dispute. I mean, the new points of dispute, and whether this is right or wrong, it's obviously can be right as a general point, have allowed us to take points we didn't take before because of the new bill. And one example I gave is we've challenged the grade attributed to a particular Fiona. But no one has suggested, and there's evidence, which again may not be of great assistance in construing the rule, but the claimant's evidence never suggested that doing what we required was onerous. And I said, only partly tongue-in-cheek, that if they really spent as long as they said they spent preparing the bill, it may be the effort was on stripping out the detail of the name Fionas. I don't know if that's right or not, but I mean, that's the last swipe I will have at the enormous time spent on preparing this bill. But it's never been suggested that what I say the rule requires is onerous. And indeed, it would be a surprising suggestion, because if you have the software, as I believe is increasingly the case, and I'd be surprised if a large firm such as the Claimant Solicitors didn't have it, but I don't know. That's one of the merits of this bill. You can just transfer it across from your time recording, and you don't have days, weeks, or hours of a cost draftsman drawing up an entirely new document from scratch. My lords, could I just turn my back on the court for a moment? Or my lords, unless there's anything else I can assist with, those are my submissions.
Thank you very much, Mr. Mr. Brown.
Just three things. If I may, I'll try and deal with the Hutton report point you raised earlier. I heard what it was. Just by way, first of all, the general points by way of overview, and that my learned friend has mentioned, one only has 21 days to respond to the bill. Well, one really has to look at detailed assessment proceedings in context. This bill was never going to be replied to in 21 days. Between the two firms, they agree extensions. People may not like it, but costs litigation has become akin to mainstream litigation. And by that, you have the regime of Part 18 requests within costs litigation. You have Part 36 regime applies to cost litigation. So it is mainstream litigation, and there are bound to be matters that arise from even one of the most diligently drafted bills, be it paper or electronic, that are going to require further investigation. So my learned friend, when he says we must have the identity of grade D by name within the bill, isn't going to get him anywhere, because they won't be looking up the grade D at ILEX or the solicitor's role. They'll have to serve Part 18 requests as to who are these people, what is their grade. It's not going to take him anywhere.
Is that normal procedure to serve Part 18 requests in cost matters for details of who's worked on the case?
They did in this case.
Well, I know, but that's their complaint. That's
yes.
why we're here.
Yes, you will get, the record shows Jane Smith qualified with the Law Society exams in X. You're claiming she's 4 years post-qual. She's actually 3 years post-qualified. Please confirm.
You need to know Jane Smith. You need to know the name.
Yes, we need to know that, exactly. If you know he or she's one of 6 people, you've got no idea, have you?
Well, you can ask you can ask particularly, so the example...
You haven't got any suspicion, you ask, give us the names just in case we can manufacture a suspicion. And then when they get the names, you ask again and say, well, now you've told us this, we've dragged it out of you. 2 of them were working on the same document. One of them was working 46 hours a day.
But my lord, that's when you raise it in your points of dispute if you want. It's your choice. The point about the cost of litigation is that all of the mainstream tools of mainstream litigation are available in the detailed assessments of costs. And therefore you can choose the tool with which you used to use.
Sorry to interrupt.
No.
But if we're talking about the tools available for mainstream litigation, one of the great advantages with the civil procedure rules was the duty to cooperate between the parties.
Yes.
And one might have thought that this appeal is very much all about not cooperating.
Well, one might, but I have to take issue with learned friend when he gave evidence saying a number of bills that they have names on. It's just you'll take advice from your legal assessor on this matter, but it's not the experience on this side of the court at all. But the importance is your lordship's reference to the ubiquitous Oliver Williamson, who did a lot of work on that particular case. He even did the schedule of loss at vast extent. But the fact of the matter is, you can either deal with that by a point of dispute, say who is Oliver Williamson, he's never been mentioned before, or you can ask for a Part 18 request as to further details. And so, much as one would like to get the bill right at the...
If you just said counsel advised, counsel did this, you'd have no reason to think it wasn't the same counsel. It's only when you know that one is called Oliver and the other one is called Nicholas, they've got different surnames, think, well, hold on a moment, what is happening here?
We ask for the vouchers, or as we know them, fee notes.
But why would you ask for the voucher if it says counsel and that's enough? You wouldn't have any reason, no alarm bells would ring, you think it's just the same.
Well, I'm not sure that's right, my lord. I mean, if my learned friend's given the example, with which I do dispute, saying, or somebody may have been working 16 hours a day, the way those who instruct me have approached the matter, you will be revealed when you interrogate that spreadsheet. It wasn't just one S2 grade working 16 hours a day, it was one S2 grade working 8 and another S2 grade working 8. So it is functional. You can go into that. I agree with you with counsel. It doesn't actually arise in this bill, but with counsel, you have counsel 1, counsel 2, etc. Or you can have counsel, but you can interrogate the bill as to who is doing what when. Because if it's on the same day, you have 2 sets of 8 hours. I think my learned friend and I, from one point we are at ITEM, is that well, he's a living hard-working counsel 16 hours a day, or else there's 2 counsel working on something very similar. So the point I make is that as best as one would like to get this bill correct and informative at the outset, there are matters that my learned friend complains of, particularly the grade D that I've given as an example, which still have to be interrogated further, be it by the point of dispute, or be it by Part 18 requests. And even in this litigation, learned friend, when we're dealing with trying to explain the President A in the paper bill, saying, well, the parties may have known each other. In this case, there are only 2 partners, renowned nationwide, one dealing with the Court of Protection, one dealing with this clinical nation's case. Firms such as Keogh's on the other side and those instructing OMH, they do know who the leading partners are, they do know who the grade A fee earners are. So one doesn't wish to make problems where they arise. But coming back to the actual question and answer, we disagree with the stance taken by my learned friend that the President S can inform what the definition of detail is. Because I think the word used by a number of people in this court today has been, the rule says this, the rule says that. It's not actually a rule of court. This is the whole regime for this electronic bill and the paper bill is by way of a practice direction. And I have indicated to your lordships in 2 cases, I can just give you the references, the case of you in Liverpool, where this court reviewed the state of the practice direction. It's a paragraph 48 in the case of you, and in the case in the Supreme Court of NHS Trust at paragraph 98, where the practice direction can't create a legal obligation that doesn't already exist. It's guidance in the civil court.
I wonder whether that is actually true here, in the sense that if you go to CPR 47.6,
Certainly.
that says that detailed assessment proceedings are commenced by serving a copy or copies of the bill of costs as required by the practice direction. So it's not a practice direction coming out in the abstract saying what people ought to do in a particular circumstance. This is a practice direction being cross-referred to in the rule, so that it really has the status of the rule. You have to serve a copy of the bill as required by the practice direction.
Yes, under what the first document I took you to, I think, was a notice of commencement.
But what I mean is, when you say, well, there are these cases where courts have doubted the significance of practice directions, there not are they cases dealing with a situation where a rule has brought in the practice direction and made it apply.
No, but this practice direction particularly, I mean, that's an interesting point your Lordship raises, in that the rule refers to you must follow the practice directions to get your detailed assessment not only up and running, but comply with it as you go through. But the main obligations there with regards to time limits, etc., are rules. The format of the bill, sorry, I don't mean to interrupt.
No, go on.
The format of the bill is actually within the practice direction.
But here it says, in the rule, you have to serve a bill as required by the practice direction. So be it. What is required has been, for convenience, put into something called a practice direction.
Yes.
But really, it has the status of a rule, doesn't it?
I'm not sure if it does, my lord. It's the rule. The rule says this is how you should do it, following the practice direction.
As required by the practice direction.
There would be a breach of the rule if you didn't comply with the practice direction, because the rule says you must do that.
Yes, but then
It doesn't matter whether it is the practice direction. So the rule says you must comply with the BNO. The BNO is the rule, but the rule says that's what you've got to do.
I follow that, and that's why we bring Ainsworth, where Ainsworth says you must draft your points of dispute, you must do it in this way, you must individually object. Here, we don't have the direction that you must use President S. We have President S is available, other spreadsheets are available, but they should perform these functions that you just looked at. And that's maybe the issue between us, my lord, you have to resolve. That going through those sub-paragraphs as I did earlier and going through them again with Mr. Marvin, was to, can you let a president dictate the definition of what those words actually mean? And that's the question we have to grapple with.
So can we just focus on that? Suppose that we can't use precedent S to guide what is meant by detail in the body of the paragraph of the practice direction.
Yes.
What does a bill have to contain?
Well, it's certainly not a free-for-all. First of all, if we go to the heart of it, you have to set out which fee earners you are claiming for. Now, I'm not saying that includes name or initials. You have to set out the category of fee earners you're claiming for.
And where does it say that?
Well, because otherwise you won't be able to formulate your bill as to your hourly rates. That still follows on from previous paper bills. That if you're to come to a figure at the end, the figure at the end is determined by two things: the person doing the work, the hourly rated charges, and the number of hours spent.
But the category isn't the thing that helps you determine the bills. It's the work done by individuals. You've chosen to describe a group of people's work together, but it's the individual components done by each of the individuals that, if you're going on the basis that we've got to be able to work out the costs, because this is the bill of costs, and costs are the charges that you've levied for the work that people have done, there's no space there for categories at all. Categories is your own shorthand.
You and I agree, my lord. There's no difference between us here. Because when you look at this electronic bill, who's the person doing that work? It's an S2 fee earner.
It's not a
So
person,
that is an
that's
individual.
a category. That's a concept.
No, it's, well, I'm afraid we beg to differ. It's a fee earner with that status who's performing that work. That is an individual. But they are charging at the S2 rate.
Anyway, I'm taking out of response to my lord's question about where do you get the requirement for categories being named, or anyone being named?
Because my lord, it's great ideas from behind come. The fact of the matter is, how do you get your final figure at the end of the bill that the other side have to play? It has to be by hours, hourly rates, and the fee earner. Those are the, now what this bill demands is actually more detail as to that, as to the detail of the work that was actually done, which we didn't always get in the old paper bills. It could have been conference or whatever, but these bills require...
So why is that required? You say you get more detail in the new bills.
Yes.
Where is the obligation to provide that extra detail?
Well, my lord, it comes from two sources. It comes from the need of the functionality of the President S or other spreadsheet of the A to E, because there you are having to look at report and aggregate costs based on the phases, tasks, activities and expenses. Now those, in A, those phases, tasks, activity, expenses are now wholly reflected, as you'll have noticed, in the narrative to the same ones used in cost budgets. So for each stage of the proceedings, witness statements, discovery, disclosure, experts, conferences thereon, trial prep, trial, joint settlement meetings, etc., you will have your phases of work. So that's where the detail has to originate from. When it talks about phases, tasks, activities and expenses. Then you have report of the summary totals in a form comparable to present tense. Well, again, when you've got all the work within a particular phase, activity or task, you're going to have a figure at the end that will be carried forward to the final summary of the spreadsheet. C allows the user to identify in chronological order the detail of all the work undertaken in each phase. So there, my lord, there's a direction within the practice direction itself. And then the final two, having dealt with what should be going in, the final two of D and E require the Excel spreadsheet functionality here, as to actually be able to recalculate intermediate and overall summary totals of input data as changed. Classic situation, £400 per hour grade A partner is actually 365. So by the press of a button, the grade A fee earner fees are all recalculated on inter-parties basis. And then finally, contains all calculations and reference formulae in a transparent manner, just to make its full functionality available to the court and all other parties. Now, this is an interesting point, my lord, in the exchange between my learned friend and my lord, Lord Justice Lewis, as to whose functionality is it? The court wishing to determine certain matters, or the paying party wishing to interrogate the bill as to what may happen. It so happens its functionality is available and the ability to be used. But we say by not having the name, by having two S2 fee earners in a particular type of work where you've interrogated as to what happened on Thursday the 15th and who was doing what, you are able to drill down there. Lord Justice Dingemans' point, is a duplication there? Are the two fee earners doing the same thing, or is there an S2 and a grade D? Well, we say that the name is not so essential to these criteria of what is required to go into an electronic bill.
It's not just functionality, it's full functionality. Is there any significance to the word full, maximum, the most you can do to make it functional? So wouldn't that be more consistent with names as well as categories?
My lord, rhetorically, I don't mean to be, I want to assist the court, but yeah. So where do we stop? I mean, it is full functionality as to how many spreadsheets, etc. we have. The full functionality must be of that particular spreadsheet as it's set out. Now, if there are matters missing, one can particularly demand further information under A and B and C before we turn to the functionality of the document. But that is why we reject the notion that, because President S has names in it, you then can go back to, actually as a matter of interpretation, to see what A to D are really driving at. And my lord, the Hutton Committee may well have, they were dealing with a number of matters of J-code, recording information and then presenting it before I think we got to the, as Leonard rightly says, the trial period. But That's not what is in the rule. That's the difficulty here with and yet another idea along the way, another investigation, another very hard-working committee as it happens, coming up with their proposal is actually how it ends up in the rules that those who instruct me have to follow and others in the profession. So we acknowledge that we believe the overriding objective is complied with by presenting the bill in this manner, and we believe one can't, if questions are asked of it or points of dispute raised on it, my lord, then they'll have to be dealt with. Because at the end of Master Nagalingham's judgment, he said, if certain information is not provided, as my learned friends touched upon, then if there's doubt as to the sums to be paid, it'll go against the receiving party and in favour of the paying party. And so it's in their own interests to actually present this in a way that they see fit, but also complies with the practice direction and, my lord, the rule. So I didn't mean to be so long, but I hope it's of some assistance. I think those are the matters I wish to raise, save for, I think you have now the distinction between status and between grades.
I would like to take you back to paragraph 104 of the judgment.
Page 90, yes.
And we had the debate earlier in relation to the grade D type people. And I'm afraid at that stage I didn't have properly in mind the fact that the judge said that status involved providing years of post-qualification experience.
Yes.
On that basis, there definitely is a problem with the paper bill, isn't there? Because you can't see years of post-qualification experience in the paper bill.
Well, yes, you can. What you can't see is litigation experience. What the grades from the SCCO add on, my lord, are litigation experience.
I follow that. Just aside from that for a moment, partner. I mean, that certainly doesn't tell you post-qualification experience.
Where are you looking, my lord?
Sorry, I'm back at page 61.
Certainly. No, the President may not give you that. The fact of the matter is, we would say that we have provided that in our paper bill, and that our paper bill is not a problem.
Sorry, you dropped your voice.
We say our paper bill is not a problem because we have given more information than was in the President A.
But if you've accepted that the judge is right at the end of paragraph 101 in saying that providing status requires you to provide professional qualification and years of post-qualification experience, you haven't done that, have you?
Well, we say we have, where we say up to 8 years experience, up to 4 years experience, etc.
But the partner
doesn't have that on page 61.
I mean, I think the point taken against you, rightly or wrongly, was a partner, in fact, can have 0 years experience, just have bought into the practice, etc., and been made a partner.
Yes, and also, I think at the same time, as I've heard correctly, when you look at next to the partner, you see the hourly rate being claimed. The argument that is so a person with 5 years experience can be a partner, but they can't be claimed here, is self-evident in the status that you're giving as partner, and that hourly rate being claimed.
The status and the hourly rate are separate. They're separate in the rules.
I mean, that just may mean that you claimed an absurd hourly rate rather than proving your point that we can work out who the partner is.
Well, in that case, I come back, the point can be taken. You dispute it. So we're making you an offer. We're not going to deal with that. I mean, for the partner to
the starting point is you must put in a bill that complies with the rules. And either on page 61, about 10 lines down, the partner description does comply with the rules, or it doesn't. It's no good saying, yes, I know I killed it, but they could have complained about that and gone to court. That's not the way it works. You've got to comply with the rules first.
yes.
And partner from 1st of April 2016, as my lord points out, doesn't say anything about post-qualification experience.
Nowadays it doesn't. I mean, obviously, as a matter of history, it said a lot more.
It said a lot more, as a matter of fact.
But this is 2016 to 2017.
It never told you that much about post-qualification experience, or indeed, well, about post-qualification experience. You could theoretically become a partner within a year, couldn't you?
I suppose anything could happen in 3 months. I don't. It's difficult to say if that's the case. But the point is, then I suppose you have a member of the bar transferring.
Yes.
But
Do we know if the solicitor, the 4 years experience, includes the 2 years as a trainee and 2 years after becoming fully qualified? Is it inherent in the phrase solicitor with over 4 years experience? The 4 years experience is as a qualified solicitor.
the phrase to be taken as post-qualification experience. That's
okay. So it's litigation experience on the partner that's the problem then?
Yes, and not grade D, where we would say.
Yes.
But the difficulty with it's difficult with the partner as to this is the basis that the status should encompass, if not professional qualification, the number of post-qualification experience. I take your lordship's point that you could stick, I'm not being facetious, but Mickey Mouse in 1,000 an hour. It's not going to get you very far.
Or shouldn't.
Maybe you don't know it's Mickey Mouse.
Who knows? Let's see if you give me a moment. I think that is the most I be able to help you with.
In which case, Mr. Brown, thank you very much. Thank you both very much for your helpful submissions. As you'd expect, we won't be giving judgment here and now. Judgment will be reserved in accordance with what has become the normal practice. I think judgment will be handed down remotely, but even if it were not remote, there would be no need, of course, for anyone to attend in court. In the normal way, you'll be provided with a draft of the judgments, of course, for you to correct our English rather than to re-argue the case. And we'd be grateful if you would put in, seek to agree in order before the hand down, and if there are points on which you disagree, could you please provide us with short written submissions, and we'd expect to settle the points in the order that we make. But thank you both very much.
I will, thank you.